Good afternoon, everyone. Welcome to our latest episode on our podcast here with AmLaw Group, where we talk about all things related to business immigration and other options for relocating and transitioning to the United States. And today we are going to talk about a really hot topic. I can't think of even a topic that probably shook the immigration world more over the last couple of years. And that is the new policy that came out at the end of May, where the Trump administration said, we are only going to grant adjustment of status where administrative grace, I like how they use that word, administrative grace, or our discretion extraordinary discretion would allow the client to do so. So this is kind of challenging practices that have been in place probably 70 years or so. And obviously it's gotten a lot of people worried about how to handle adjustment of status here in the US and whether it's still possible, or if it is possible, how can it be best accomplished? So to help me answer all those questions today, we've got my esteemed colleague, Yulia Novik, to join us and go over all of this. Yulia, how are you doing?
Good. I'm good, Charles. Thank you. Thank you for having me.
Absolutely. So it's probably not exaggeration. You've been doing immigration for probably at least 10 years. I've been doing it maybe 18 years. I'd have to say this was probably one of the most surprising pieces of news to come out, right? I mean, I can't think of maybe some of the travel bans affected, some countries, and that was pretty important. But I mean, I think this was kind of a jaw dropping when it came out. Wouldn't you agree?
For me, no.
Well, why
Honestly,
on the
Charles,
show? You're supposed to agree with me. My gosh, here we're gonna. Why was it
honestly,
not so
Charles,
surprising for you?
when I looked at it, probably we are already immune after everything that happened last 5, 6 years. Started not from immigration, starting from COVID and then immigration and everything. So I kind of expect every day something new. And it challenges you. It makes you think. It makes you become better attorney and help your client. So you read the policy, you understand what it is about, and it's not so complicated.
I think why you like it so much is it just gives you job security, right? There's more work for lawyers, more challenges, and so
Charles, I told you I want to get certified in federal court, and after September 30th, start going to court finally.
there you go.
Yeah.
So this is a good thing. So I was not this so for everybody to know, these are not pre-rehearsed webinars or podcasts we have, and I have to say I was surprised by Yuli's answer, but it's great. It adds a little spontaneity to the conversation, and I think the rest of this conversation will be kind of interesting too, because I think we both have some slightly different views on this. Well, anyway, I know what you're saying, Yulia, in that maybe we shouldn't be too surprised by this because obviously the Trump administration is not a big friend of immigration, not a big friend of illegal as well as legal immigration even. And so I guess we could say this shouldn't come as a big surprise, and I think there's things that we've seen over the last couple of years that have kind of been moving this direction that we could have probably anticipated, something like this.
Charles, agree with every petition when I started early 17, we've been developing. You look at the weight and size of each petition, each category. Every time it's larger and larger. We get more RFEs with questions we've never received before. So for each new client, we have new strategy.
You know what? That's actually a good data point we should be tracking, the weight of our petitions going out. And if we compare that over the last 9 years, and maybe our legal fees should be tied to the weight because obviously if there's more papers, more documents we have to prepare, more legal arguments we have to configure and put together, maybe that
I like it.
yeah, that's a good idea. I never thought of that. So we won't share that with the clients. We won't tell them how heavy their petitions are. But I would agree they're getting bigger and longer, and the government seems to be coming up with more and more complications and challenges to things. So it does keep us busy. But anyway, if we get back to this policy, so to make sure we're on the same page with everybody, about May 21st, 22nd, this new policy out of the blue, there weren't any discussions about it. They kept it under wraps for a long time, came out. And I think the initial response from everybody was, "Oh my goodness, they're outlawing, adjusting status. If you're in the US and some other legal status, we want to get an immigrant status, you want to get a green card, they're not going to allow us to do that." So I think after people calm down a little bit and the government even kind of clarified some things in the following week, we realized that, okay, maybe things aren't quite as bad as it was portrayed. And there's no outright ban on adjustment of status now, especially taking into account some of these clarifications that USCIS has issued. And I think to summarize it, I think the best way to summarize it is the government's not creating a new policy here. They're just taking existing law and policy and explaining how they're going to interpret it going forward. Now, whether they're interpreting it in a manner that's consistent with the law, that's questionable. And I'm sure there's going to be a number of lawsuits challenging this whole new policy. And I think those challenges will have some good chances, depending again exactly how the government's going to apply this. If the government is a little bit more liberal in applying it and they kind of scared everybody with their bite or their bark, I should say, but the bite is going to be a lot softer, then maybe, there won't be so many legal challenges. But I think, Yulia, and you could give me your thoughts, but I think what's happening now is the government is saying, we're not going to just blindly give everybody, the immediate option to adjust status without checking their background, without checking their circumstances, without checking the reasons why they're doing it. So they're not closing the door. They're just saying, I think, we want to get more information and deal with this on a case by case basis. You think that's true?
I agree with you, Charles, completely. They are not saying we're not gonna give it to you, but they're not saying we're gonna give it as before, as we used to, just to every person. What I like, why I wasn't surprised and why I was calm after reading policy, the language, it's not harsh. I even like the phrase officers are reminded they are to consider all relevant factors. It's not like officers must look at this and this. They just reminded to look at relevant factors. So I would say, yes, for people who are in this situation and they're waiting for adjustment or they were planning, of course it may be scary, but it's not as scary as it looks if you plan your immigration
Right,
correctly.
right, with a good experienced attorney. I would agree, and I think the biggest unknown factor right now is probably how exactly the government's gonna apply this discretion, and I think over the next month or 2 or 3, we and other immigration attorneys are gonna get a good idea of how exactly they're applying this, and once we have a better idea of their position and what factors they're looking at, it'll make our job a lot easier, and we can more effectively work with clients to proactively prepare those positive factors, what they call positive equities, to build up the client's case and come up with, convincing reasons why they should have the right to adjust status here. Now, there's one thing I think everybody has agreed on, which I think USCIS has agreed on and attorneys, including yourself, is it's not going to be enough just for somebody to not have any negative factors in their background, right? So they're not just going to say, oh, you have no arrest record, you have no overstays. Okay, we'll let you adjust. That's not going to be adequate. I think what the service has made clear is that they want to see positive reasons, positive explanations, proactive equities or proactive evidence to show, hey, yeah, you really do have a good reason, why you should, adjust status here. And I guess that could vary based on the visa category, right, Yulia, as to what they're applying and what factors they'll look at.
Of course, Charles, and it's like you have to have good moral character. You should not have any arrest records. You should not overstay your status here. They are gonna look at it, but it's not enough.
Right.
It's a must, but not enough. You have to show there is some benefit to United States.
Right.
You have to show that when you entered United States, you did not have intent to file for adjustment of status. And you also have to show some hardship why you cannot go back to your country and receive immigrant visa. Basically, I think we broke it down to four main factors, right, Charles? Nothing negative, something positive for US, intent entering, and hardship going to the
Right, right.
consulate.
Yeah, it's kinda yeah, it's the interest rate, yeah. You scratch my back, it's kind of like, you don't do any violations or have any, problematic history, and at the same time, the applicant, scratch the back of the US government saying or showing, "Hey, this is the benefit you're gonna receive by allowing me to adjust status." And I think maybe a little bit later in the podcast, we'll talk about what those factors could be based on your visa status or immigrant status and what factors you might bring into play to convince an officer that, hey, I'm going to be of value to the US and you should really consider this. So we'll talk about that in a little bit. But I want to get back to that one point you mentioned about preconceived immigrant intent, because that's kind of where things are all going to start at. And so I just want to make people clear what that means. So preconceived immigrant intent means that you knew you were planning to apply for a green card before you actually entered the US. And I think that's one of the focus points of this new policy is the government kind of wants to go after these people who didn't have a change in their, life or some life-altering events after they came to the US, but they're gonna kinda go after people who knew before they came to the US they wanted to change their status, and they kinda, hid it from the officers, hid it from everybody, waited 90 days, and then filed. Again, there's nothing wrong with that, and there's nothing, illegal, I believe, with that, and we've done that for years and years with people, right? But they're gonna start digging at the evidence to see, did you have this preconceived immigrant intent? Because if you did, then I'm afraid that's gonna make your adjustment of status more difficult, even if you have some positive factors that you can bring into play, because I think that's what they're trying to focus on. So, what is how are they gonna determine if you had preconceived immigrant intent? That could be done in a variety of ways, right? They're gonna look at a lot of factors, and I know already in the few weeks that have passed since this new policy came into effect, they've been calling people in for interviews, and we know from talking to other attorneys and other clients what questions they're asking. And I think what they're asking in their questions is trying to get at, okay, when did you make the decision that you were going to stay in the US and adjust for status? And if they can point to evidence that you made that decision before you came to the US, you're going to have a tough challenge looking at you. So I guess the first advice we'd say, Yulia, right, is, don't, rent out an apartment before you come to the US for like a year or something like that, which shows that you're planning to stay here a long time, not just for a short tourist stay.
And don't sell your property or finish cancel long-term rent in your country, because I think if you have it, it's also another evidence that you were planning to come back.
Sure, sure. And we could play hypotheticals. What other shows immigrant intent? We could think about it. If you come here with all your pets, most of your belongings, they ask you, what did you do when those first couple months when you're here? I mean, that's a good point too. I think they're going to start asking people. So if you came as a tourist, they might start saying, hey, show us, what did you do the first couple months when you were a tourist before you made the decision to immigrate? And if all you can say is, well, I just sat in my apartment working on my computer trying to develop my business concept, that doesn't sound too much like a typical tourist activity.
So they've been asking us in other change of status cases from non-immigrant to non-immigrant for a while about it. Show us tickets where you went. So go to the beach, go to the museum, go to Disneyland, anywhere, collect all those documents,
Right.
pictures.
And show that you really were a tourist and you were planning to become as a tourist, and then
Yeah.
later show something changed in your life and the plans. You got a job offer, you had an investment opportunity in the US. You found out about a regional center project that was too good to be true, or a slot opened up in a project that you really wanted to invest in. I mean, I'm making some of these things up, obviously, but yes, we're gonna have to kind of explain why after you entered the US, you came up with this idea, you had these new plans to stay here. So that's the first thing we have to show, the absence of preconceived immigrant intent and a change of your plans after you arrived in the US. Now, I think the other thing that you mentioned, Yulia, that's important is talking about building up those positive equities. So showing that good behavior and showing, the benefit you're going to provide for the US. So here, I think it's helpful if we go through a number of specific visa categories or status categories to talk about what would be good evidence to provide. So I suspect this policy is targeted most of all at people that are maybe students or tourists, and they then file maybe based on marriage, based on family reunification. Their mother came to visit them, and then they want to sponsor their mother here. While she came as a tourist. I suspect this is what that policy is targeted at, and so I think these kind of situations are going to be the most challenging for people, right? So
I agree with you, Charles. I think here it's the same advice that we already gave for tourists, the same advice we can give for students. Don't drop out of school right away. Don't miss classes, even if you can miss classes. Make sure you communicate with your teachers so someone can give you a letter of recommendations that you're a good student, that you're a good person. Participate in some positive activities, even charities events. No one is telling you to give up your money. Just go there,
time.
be people
Yeah.
for animals, do something positive so people can think, yeah, we think he deserves to stay here.
Yeah. And you know what? I think this is going to be a very subjective standard. And so it's almost a matter of creating warm, fuzzy feelings about people and creating a positive glow, if you want to call it, a positive aura around this applicant that, okay, he's maybe not the smartest guy. He's not the next Einstein, but yeah, he's a good student. You don't want him to go back to his home country. There might be delays. He's going to miss classes. He might, kicked out of school if he misses too much time. He's volunteering at the local animal shelter. He's providing a positive contribution. I think as silly as these things maybe sound, I think those are the things that will help build up a good case. And again,
Again, about school, because I am the one who went to school here, who went to several schools here, go to those networking events. For students, they tell you in each school, go to networking events, go there, reassure yourselves that you have people who can draft you intent letters or job offers. So it could be a good argument telling an officer, if I go back to my country, they will not wait for me for 2 years. But I have an opportunity, I already have secured a job offer.
Right. I think the biggest challenge is probably going to be with people looking to do family reunification, right? And this is really on a case by case basis. Maybe if your parents came to visit you, you're a US citizen and you decide to sponsor them and you want to adjust them here in the US. What's the compelling reason for them to be here? Possibly if they have health issues, maybe they have challenges traveling long distances. I suspect it's difficult to come up with a case. Well, my mother, is volunteering, here in the local community. And so that's a good argument. I mean, if it's possible, but I suspect, parents tend to be older in age, might not speak English, stuff like that.
What's interesting, usually, Charles, I think we bring our parents. And that's important for me too right now because I told you I'm planning to bring my mom, and now I will have to create an argument because as one of 75 countries participants, she cannot go to consulate, at least for right now. So yeah, the argument should be not for the person you bring in, because if I'm bringing my mom, obviously it's harder for her. She's older. The argument has to be that hard for me. So the person, and I do think that it's more often that children bring parents here than parents leave younger children over there.
Right, right.
So yeah, think about the argument for yourself why your parents should not go to consulate. What is hard for you?
And here's an issue we were discussing prior to this, I know, whether whether the fact that 75 countries are on the, don't issue a immigrant visa list, whether that could be a good argument for adjusting status here. I mean, it could cut both ways, right? The government might say, well, that's not a respectable argument. On the other hand, if you literally cannot get a visa overseas because there's this pause that's been implemented, you could have an argument that justifies your adjusting status. It's a fine line. I'm not sure which way we would recommend clients, but it's something we're going to probably develop over the next couple months.
Yeah, that was an argument I wanted to use, and I read the law which says you should be eligible for the visa. I started doubting myself.
Yeah,
But then, Charles, I think people from 75 countries, they are eligible to get
sure.
visa, and they
Right.
actually do go for interviews.
Right.
It just temporarily there is a test.
Yeah.
So I think we should still use it as an
Yeah, I
argument.
think it could be an effective argument. I think so too. Absolutely. So let's maybe talk about a couple categories and then, and we could kind of rank them, how difficult it might be or easy to adjust status based on the status you have currently. So we just talked about tourists, students a little bit, stuff like that. Let's say you've got like an O. Well, here's the important thing. If you've got an L1 or an H1B, you really shouldn't have any concerns because the memo clearly indicates that these are dual intent visas. And since they're dual intent, it's okay if before you came into the country with that visa, that you were planning to immigrate and stay in the US. It's okay. And they acknowledge that, fortunately. It's pretty clear in the law. So if you've got an L1 or an H1B, you really should have no problems if you later want to adjust status. So that's the good news, at least. But then let's say, for example, let's say you're a talented, whatever, artist, singer, performer, and you want to file for an EB1A. How difficult do you think they would be able to make a case for allowing an EB1A candidate to adjust status?
It's hard to say because I think B1A, because by itself you have to show for the petition benefit to United States, you should have an argument. But still, transferring from student, for example, a tourist to B1A directly, it's too harsh. So I would, especially for tourists, you here for 180 days, and within these 180 days you have to apply. It's too obvious. I would call some other visa types as transitional ones. So we have the ones who do not allow it, tourists and students. We have the ones with dual intent, L1 and H1B, and I would call O1, E2 as transitional probably. So even if you finish in school, I think if you have finances to open some company, try transferring to E2. Because you're a student, you may not have extraordinary abilities yet. If you're a tourist who is coming and wants a B1A, try to transition there softly also. I think filing for O1 is going to be safer, and stay for some time, at least a year or two in O1 status, so you already able to do something, and when you go for interview for adjustment of status, you show the actual benefit, not something you're gonna give later.
Right.
But what you've done already in OWASP status, you will have partners, you will have clients who are able to write you letters. So I think the transitional path is the safest one.
I think I'd agree, the transitional path of using some other intermediate visa category like an E2 O1 is a good idea. But I would have to say we have to be practical as well. And probably for most of our clients, well, I shouldn't say most, but at least a large number of clients, that path might be too long or too expensive, right? Because if you have to pay the fees to get the O1, stay in that status for a year, then you switch over to EB1A. Even though that's a very typical path in the past, it has been. I suspect for some people that might be burdensome for a number of reasons. So I certainly agree that's a safer route to go. It's just a question of, do you want to go the safer route, but maybe a little bit more expensive and it's going to take more time? Or would you be willing to take the risks and immediately say file for an EB1A or an EB5? I think with an EB1A, again, I'm just speculating. We're not talking about a specific case, so it's difficult. But as you mentioned yourself, an EB1A inherently has to show some benefit to the US. We've even been getting a lot of RFEs lately where they even say, oh, you've met 3 or 4 of the categories for the EB1A, but you haven't shown the national merit, that you're going to really provide a benefit to the US. So if you're able to show that benefit to the US in the EB1A petition and you get it approved, I think generally probably your chances are better that you can do the adjustment of status, because if you're able to show there's national merit in your activities as part of the EB1A, I would hope for the 485 adjustment, those arguments
And
would prevail.
Charles, I like to mention right now my new discovery. What is the benefit to the United States? Because that was my biggest challenge, how to prove it for EB1A. So basically, the virtues that you employed in the area of your extraordinary abilities is a benefit to the US. So if you're in tourist status, it's a problem to be employed. You cannot show it.
Right.
But if you have letters of intent that you will be employed or even a job offer, it's already you're not breaking any law, you're not working when you're tourist, but you're waiting to get your green card over here.
Right. A lot of our potential EB5 clients are worried about this and how that would apply to them. So there's several lines of thinking here. I've talked to some attorneys who've said, hey, EB5 probably has the easiest arguments that they can make, because they could say, even though I came as a tourist and I'm what I'm just now based on my EB5 petition, who's contributing more to the US than a person who invests 800,000 in the US economy and is obligated to hire 10 new people as a result of that investment? So I see that line of thinking. That is a pretty compelling argument. How the officers are going to relate to that, we're not so sure, because I do suspect at the same time they're trying to weed out these tourists who maybe are coming here to come here, avoid consular processing, and then adjusting on an EB5 or maybe an EB1 and stuff like that. So I suspect these are kind of the targeted individuals based on this new policy, and whether an argument of that, well, I'm investing 800,000, what more do you want? I'm not sure how effective that is. I think you're kind of skeptical about that argument.
Yeah, like about policy memos that I wasn't surprised. I'm skeptical. I am more pro even NIW B1A because the policy memo mentions benefit to the United States, and the benefit from person being here is immediate. If you proved your benefit in your petition, EB5, you already invested, and most clients invest in EB5 in regional project EB5, so the money is already there. And officers know you're not really doing anything.
Yeah.
It's more like a passive investment. So for me, you would not convince.
We'll see. Trump has made various noises, whether he likes EB5, he does it. I think he has a love-hate relationship with EB5. Yes, and I think over the next couple of months, we'll see, by just talking collectively with other attorneys, how that argument of, gee, I'm investing 800,000, what else do you want? Would that appeal? If I were an EB5 client, what would I do? Like you mentioned, Yulia, certainly a very safe route would be maybe changing status to an E2 or an L1 and then filing the EB5, because certainly with the L1 and most likely with the E2, you could show the benefit to the US. You've got a business you're operating, you've hired, if you got to go do consular processing, you might get delayed, the business is going to suffer, jobs will be lost, stuff like that.
And clearly, when we're talking about EB5, if you already invest in 800, most likely you will be able to invest a little bit more in your
Mhm.
own company. But yeah, you have to work, you have to develop it, because just investing, getting into status is not going to work, because even changing status and especially adjusting a status, the point of this E2 will be show that it's operational.
Right.
show tax returns, show that you employed someone. You
And
have
I
to
think
work.
I think in the EB-5 case, in any case, but, especially in EB-5 as well, they're gonna look at this preconceived immigrant intent that we were talking about earlier. So I think, I could be wrong, my personal opinion is that if, let's say worst case scenario, the client just can't create an E-2 or an L-1, doesn't have the money or the qualifying companies, or they wanna get everything done by, September 30th of this year. What are your chances if doing an adjustment of status from a tourist status? I think probably one of the deciding factors is whether they can prove pre-existing immigrant intent. So if they can show that before you came to the US, you were planning on staying here, you rented an apartment for 12 months, you didn't do any of the things that tourists typically do when you came here, stuff like that. I would say you'd have a challenge, definitely. But if you can provide, evidence that you didn't have this preconceived intent, or at least they can't find evidence that you had that preconceived intent before you came here, and you can get some positive, benefits from you being here. And like, even like you said, Yulia, if we really get desperate, start volunteering at a local charity and doing some other positive things in the community. Does it seem like that's kind of flimsy stuff? Maybe from a legal perspective, it's kind of flimsy, but on a psychological level, I think it helps. It's not a guarantee.
And it's how many things survive in United States. There are actually many volunteers, Americans volunteers themselves. I know it's not so usual for some other cultures,
Right,
particularly mine,
right.
but this is something great. And Charles, I wanted to mention about intent entering the United States. Times people are confused. They think that if no one asks them at customs
Yeah,
what they're planning to do, then they did not declare their intent. No, it's the virtue of you coming here with B1, B2 visa, or if you come in as a Canadian without a visa, with a visa waiver, but you come in B1, B2 status, you declaring your intent to be a tourist without saying any word.
right, right. So I think in any case, whether it's an EB-5 situation or EB-1A, EB-3, the important thing to summarize kind of all this is you're gonna have to provide, you have to collect what they call the positive equities. So those pieces of evidence that reflect positively on you, your personality, your contribution to the US, both socially and economically. And this has been definitely a theme that the Trump administration has been repeatedly using, maybe in other immigration contexts with asylum and stuff like that. But now we're seeing they're more broadly applying it. So for anybody looking, at adjusting status, I would say you need to work with your attorney to start collecting those positive equities, because it's not enough just to have no violations, but they're expecting to see something positive by you adjusting the status, and also something, some good reason why, you couldn't go back to your home country. And those could be a variety of reasons.
Charles, I feel it's like United States is trying to teach our tourists good manners. So they're doing something, not doing anything, that they not just getting education, they getting a good job, they produce
Mhm.
something, they do charity. So actually nothing bad.
No, it's not bad. I think the administration could do a better job of more tactfully and diplomatically applying some of these things,
Yeah.
instead of these.
Not so abrupt.
Yeah,
Not
yeah,
so
yeah. I think they thrive on chaos. I think we've all learned that. So, but yeah, there's nothing wrong with that. I mean, actually, it sounds like some of these standards they're holding future immigrants to exceed standards we have for our fellow citizens. So, in that respect, maybe it's not totally fair, because I know a lot of US citizens that maybe don't even deserve that, but they were born here, and so that's how it is. We can't change that. But anyway, yes.
yeah.
So I think it's a matter of, building positive equities, showing what a contribution you'll make. And as of the time of this filming, which is early June 2026, as time goes on over the next couple months, we will update our viewers with new information that we get as to how they're applying this, what factors they're looking at, what criteria they're using to decide, hey, are you nice enough and good enough, to merit an adjustment of status here in the US. So hopefully this was as helpful to people. I think in summary, we would say things aren't quite as bad as what the initial response was. We've dealt with more challenging tasks and challenges in the past. So I think with any attorney who has good experience, you should be in safe hands and should be able to successfully get things through. But we'll certainly keep things posted as things evolve, and provide you with updates on this and other topics related to business immigration. Yulia, any other closing thoughts from your end?
No, I'm silent, Charles.
Okay, well,
I
that's
think
good. That means I did
it,
my job well. If you have nothing else to add, that means
You did
You
good.
did the job.
Immigration
All
is not
right.
so bad. Just what I want to say, it's still all possible. No one prohibited you from immigrating.
Okay. So the doors are still open, slightly closing. Sometimes you might have to use the window in front instead of the doors, but hopefully
We're here to help to open it,
that's
Charles.
right.
We like
Right.
arguments.
We're the door openers, the official door
Yeah.
openers. So thanks again for your time, everybody. If you want to get more details about your particular case or feedback, sign up for a consultation. The details are below. We'd love to assist you as well in your transition. Thanks again, Yulia. Until next time, we'll see you then.
Thank you for having me. Thank you, everybody.
Thank you.